Hi, this is Asaziia Krichena and you're watching Legal Bites. In giving birth to our babies, we may find that we give birth to new possibilities within ourselves. With the changing times, we have witnessed a lot of women leaving homes and getting their hands on both private and governmental job opportunities. In India, as per 2021 report, 53.28% of women work outside home and is expected to remain stable even in 2023. While women are wonderfully shouldering both household as well as professional work, the work becomes stressful during their pregnancy times. So, unlike the olden days, we have a legislation that governs maternity benefits and entitles women to take paid maternity leave whenever required. Today, in this video, we will be talking about maternity leave, the amendments brought about with the passing of years, scope of Maternity Leave Act, need for paternity leave, penalties, some recent case laws, and paternity leave status in detail. First, what is a maternity leave? In simple words, maternity leave signifies a period of time when a woman is allowed to be away from work before and after having a baby. Let us first look into who is a woman as per the legislation Maternity Benefit Act of 1961. Under this act, as per section 3(o), woman means a woman employed, whether directly or through any agency, for wages in any establishment. The legislation also defines the term maternity benefit. Section 5 of Maternity Benefit Act deals with right to payment of maternity benefits. The Maternity Act was first established in 1961 as the Maternity Benefit Act 1961, ensuring that women can take paid leaves during their pregnancy times. In the beginning, the leave was for 12 weeks post-delivery, but in the year 2016, some major changes and reforms have been brought about in the previously existing legislation. The reforms are given hereinafter. First, it increased the paid leave duration from 12 weeks to 26 weeks. Second, prenatal leave has also been increased to 8 weeks from 6 weeks. Third, women who already have 2 children can avail 12 weeks of maternity leave. Fourth, if a working woman adopts a child who is less than 3 months of age, she can avail 12 weeks of paid maternity leave. This legislation is eligible for both permanent and contractual employees working in organizations with more than 10 employees. In 2017 again, some amendments were made in the legislation. They are, after the completion of the 26 weeks of paid maternity leave, the woman can also avail work from home option, but this has to be availed by mutual agreement with the employer. A crash facility has also been introduced by this amendment in 2017. The employer and the organization should take responsibility to inform the women employees of the availability of this legislation and the rights available to them. In addition to the 26 weeks of paid leave, the woman employee should be given a medical bonus of 3,500 rupees. Pregnant women and lactating mothers are also eligible to get 6,000 rupees from the National Food Security Act 2030. Let us now talk about the scope of Maternity Benefit Act. By the end of 1972, this act became applicable to the whole of India. This act applies to all establishments employing 10 or more employees on any day in the preceding 12 months in any unorganized or organized sector. Section 2 lays down that it applies to every establishment being a factory, mine or plantation, including any such establishment belonging to government, and to every establishment wherein persons who are employed for the exhibition of equestrian, acrobatic and other performances. We shall now talk about the requirement of notice under Section 6. A written notice is required to be given by the pregnant mother, to the employer stating that her maternity benefit and any other amount may be paid to her or the nominee and she will not be working for the said period. She must state the date from which she will be absent from work, and the date should not be earlier than 8 weeks from the date of her expected delivery. If the woman has not given such notice when she was pregnant, she can give it as soon as possible after delivery. Failure to give such notice will not entitle her to maternity benefit. On the production of proof that she is pregnant, the maternity benefit amount for the period previous to the date of her expected delivery shall be paid in advance to the woman, and the subsequent amount shall be paid within 48 hours of production of proof that the woman has delivered a child. Now, the question arises, why is there a need for maternity leave? 1. Uphold the principle of Indian Constitution. The concept of maternity leave has helped women to get back to work even after the event of childbirth, and has truly upheld the principle of right to work, right to treat people properly at workplaces. Maternity leave has played an instrumental role in upholding the fundamental rights guaranteed to women by Article 14 and Article 21 of the Indian Constitution. 2. Child care. Maternity leave has given the mother of the child to give full attention to the newborn delicate child who needs care and attention the most. Number 3. Postpartum care. Childbirth is a very critical event for a mother in terms of health. Through maternity leave, the mother gets enough time to recover and get back to the right standard of health. We shall now discuss some case laws. First is Pooja Jignesh Doshi versus State of Maharashtra and others. In this case, the petitioner was unable to carry a second child and chose surrogacy as a solution. The surrogate mother gave birth to a child who was later adopted by the petitioner. The surrogate mother, that is the petitioner, requested maternity leave prior to the birth of the child, but was rejected. The respondent refused the petitioner's request for maternity leave to care for the surrogate child, claiming that the leave rules and the policy controlling the rules do not allow for maternity leave for a surrogate kid. As a result, the question of whether a surrogate mother is entitled to maternity leave has risen. Without delving into the merits of the case, Bombay High Court relied on the same court's decision in Dr. Mrs. Hema Vijay Menon versus State of Maharashtra. The High Court explored the idea of motherhood and pregnancy in this decision. Maternity is regarded to constitute a period of pregnancy and the period immediately following the birth of a child. According to the High Court in this case, the purpose of maternity leave is to maintain the dignity of motherhood and to offer care for the child's and the mother's well-being, as well as for the mother-child relationship. Maternity leave is meant to help mothers and their children achieve social justice, to make a distinction between a mother who has a biological kid and one who has a child via surrogacy would be demeaning to the womanhood and motherhood of the woman who desires to nurture a surrogacy child in the same way she would a biological child. The right to life as defined by Article 21 of the Indian Constitution encompasses the right to motherhood as well as the right to the full development of every child. If the government can grant maternity leave to an adoptive mother, it's difficult to see why the government won't provide maternity leave to a mother who has a child through surrogacy. We shall now move on to the second case law, Rasitha CH versus State of Kerala and another. According to Kerala High Court, women employees, regardless of whether their job is contractual or not, are entitled to maternity leave. The maternity benefit is not merely a statutory benefit or a benefit flowing out of an agreement. Justice A. Mohammad Mustaq wrote in allowing a petition filed by Rasitha, who was denied maternity leave by the Calicut University on the grounds that the terms of her contract did not envision the grant of such leave. Justice A. Mohammad Mustaq wrote, "This court has consistently found that it is associated with a woman's dignity. It was held that a woman employee cannot be refused maternity benefits only because her employment status is contractual. As a result, despite anything in the contract agreement, the university is obligated to provide such benefits. In light of these considerations, the court granted Rasitha's petition and ordered Calicut University to pay Rasitha's maternity benefits, which are the same as those paid to other university workers within 2 months. We shall now talk about the penalties under the Maternity Benefit Act. First, penalty for contravention of Act by employers given under Section 21. If any employer contravenes the provisions of this Act or the rules made thereunder, he shall, if no other penalty is elsewhere provided by or under this Act for such contravention, be punishable with imprisonment, which may extend to 1 year, or with fine, which may extend to 5,000 rupees, or with both. Second, penalty for obstructing inspector, Section 22. Whoever fails to produce or demand by the inspector any register or document shall be punishable with imprisonment up to 1 year, or with fine, which may extend to 5,000 rupees, or with both. We shall now very interestingly talk about the concept of paternity leave. There is no national legislation concerning paternity leave in a developing nation like India that forms around 7.09% of the world economy as of 2019. As more and more citizens are quitting the patriarchal lifestyle and accommodating themselves to the contemporary and equivalent one, the most primary responsibility of nursing a newborn is being shouldered by both the parents on an equal footing now. However, it's only the mother in India who can reap some benefits out of this through the Maternity Benefits Act. Although some nations have begun to realize the wettiness of paternity leave, other nations haven't so far. The International Labour Organization report on Maternity and Paternity at Work 2014 suggests Australia introduced a 2-week paid paternity leave at the beginning of 2013. In Denmark, fathers are entitled to 14 days of paid paternity leave to be taken during the 14 weeks following the birth, which corresponds to the postnatal portion of the maternity leave. Estonia provides 14 days of paid paternity leave to be taken during the mother's maternity leave period or in the 2 months following the birth. In Finland, 54 days of paternity leave are provided as of 2013. Moving on, we will talk about paternity leave and fundamental rights. The prerogative of paternity leave in India finds its roots to Article 21, 14, 15, 16 and 42 of the Indian Constitution. The father's rudimentary right as well as duty to take care of his newborn is as fundamental in nature as looking after one's own helpless self. In the 21st century, where people have begun to prioritize both their professional and personal lives by putting them on the same footing, the concept of paternity leave comes as no exception. Article 21 enunciates that a human's life has all-encompassing aspects that concern itself to the quality of mankind's lifetime. Hence, rearing one's baby directly concerns itself with the parent and has much more meaning to it than just a paid leave, and thus, the father should be entitled to this essential break. Moreover, the right to equality entails both men and women without fail as of under Article 14. So, the leave to look after one's child should be granted to both the parents without any prejudice, discrimination or favoritism. Let us now talk about Paternity Benefits Bill 2017. The objective of the bill is childcare is the joint responsibility of both parents. They must devote time to the newborn to ensure its proper well-being, said Congress MP Mr. Rajiv Sattaf. The bill proposes a leave ranging from at least 15 days to 3 months from the date of delivery of the child. It only applies for up to 2 children. However, a new employee in a company becomes eligible to avail this benefit only after he completes 80 working days in the aforesaid organization. Similar benefits and advantages would be extended to adoptive parents as well. Failure to conform to the provisions laid down will lead to imprisonment of the employer, which would extend for up to a year or fine. The roadblock here is that this bill has not been given immediate attention and hence never came about. If this bill is passed in the future, it would give impetus to the working families to do well, both in their private and professional lives, since such benefits would help them to strike the perfect balance the parents need between the two worlds. This would also enhance their employee efficiency, all while trying to be there for their family when it's imperative and strengthening the relationships within. It would be nothing but the most righteous act to ameliorate living standards of life and keep the economy afloat and thriving. The task of babysitting is still considered a woman's job, and people won't have it any other way. What they don't seem to understand is that both parents need to share such a responsibility. However, Indian cricketer Virat Kohli broke through the shackles of this stereotype by taking a paternity leave in 2020. If many such illustrious personalities begin to set such examples, it won't be far when it becomes a norm. Furthermore, to sanction such a practice, an enactment of the Paternity Benefit Bill 2017 has the power to do wonders and bring positive changes. To conclude, the most pressing requirement at the moment is a shift in social attitudes. Absence of maternity leave would create a situation where women will be disproportionately punished for bringing a new life in the world. With the evolving humanity, a natural process like pregnancy must not become a hurdle for half of the human population to be left behind in the race of progress. I would like to sum up with the words of Quentin Bryce. Maternity and paternity leave is absolutely vital for strengthening families. It's an issue for men and women. Thank you for watching. If you like the content, please like, share and subscribe to Legal Bites.